Welcome, everyone. I'm Linda Bishop, the Vice President of National Programs for the National Association of Women Business Owners Institute for Entrepreneurial Development. And the Institute, in case you don't know, is a nonprofit that is designed to bring education and connection to women business owners across the nation. And today, I am super excited to bring to you one of my friends, and we just agreed on that just a minute ago, by the way, that we're friends. And her name is Michele Berdinis, and she is an attorney. Now, before anybody gets itchy about an attorney, I will just tell you right now that she is one of the friendliest, most fun, and most real attorneys that you will ever meet. And if you have any doubts about that, you can take a look at her logo. That's right. See, it's a cute little bee. And she is the founder of Beeline Legal and Beeline Trademark Services. And today we're going to talk about trademark services. And we're going to probably talk a little bit about intellectual property and maybe even about the AI generated images that you may be using in your marketing. We're going to talk mostly about trademarks because it's really important for small business owners to better understand trademarks, what they are, when to use them, why is it a good idea to get help with them, and then we'll find out more stuff too. So Michele, thank you so much. I'm so excited to have this conversation with you and bring you to the NAWBO Nation.
I am super excited to be here. There's nothing I like more than explaining stuff to people. So let's do this thing.
This is fantastic. And let me just say one more thing about Michele before we get going. Because Michele is an attorney but she's not in it for the money. Now, I know nobody's going to believe me when I first say that, but she's really not. She did not start her practice for the money. She started it for the glory. And what I mean by that is the glory of being part of the success story of other women entrepreneurs. And that is really what prompted me to ask Michele to share her expertise and herself with us today. So Michele, why did you decide to focus your trademark, your legal practice mostly on trademarks?
So before doing this, I was a partner at a law firm, and I represented startups. I did their formation, all their private placements of securities. I reviewed their contracts. I wrote their contracts. I did their trademark work. And then I did a lot of mergers and acquisitions. And then my children graduated from college, and I stopped hemorrhaging tuition, and I had choices. So I left my firm and I focused in on my trademark practice because that's really the one you could do that by yourself. You can't really do mergers and acquisitions by yourself. And when I was in my old practice, I was always getting new trademark clients after they got a cease and desist letter. And I don't really like fixing problems so much as I like preventing them in the first place. And so I was asking myself, why aren't people coming to me sooner in the process? Why aren't they coming to me at the beginning? And it's because they didn't have $5,000. So I realized I needed to lower the price point. But obviously, I still had to make a living and support myself. So you can only lower that price point so far before you're really not getting enough time for the money enough money for the time that you're spending. Then I realized I could automate a lot of it. For example, after I file your application, I have to send you an email, and the email has to say, "Hi, I filed your application. Here's what's going to happen next. Here's when that's going to happen. You're going to get letters in the mail. They're scam. Don't send the scammers money," right? And there's no reason why I have to write that email each and every time. So I built a website that does all the annoying parts of my job so that I now just have to focus on the interesting part, which for me is the fun part. So figuring out whether a trademark is actually available, actually explaining things to clients so that they can understand them. And it's had all these side benefits to it that are great for the client and great for me, but mostly it allowed me to bring the price point way down. And now I'm getting clients earlier in the process, which again, so it benefits me, it benefits everybody.
That's fantastic. And what a dream, right? Every business owner I know would really like to structure their business so that they get to do the part they like and
Right.
not the other parts.
Right. Yeah.
Really
Yeah.
smart.
In my old practice, like somebody would come to me and they would say something like, I really love baking, so I'm going to open a bakery.
Oh,
And I would say, oh, well, then you're never going to bake again, right?
right.
You're
Right.
going to spend all
You'll
your
be baking
time,
on the weekends for fun
yeah,
because you won't
hiring
get to do that the
employees,
rest of the time.
dealing with the health department. I mean, that's what you're going to do, right? So,
Yep.
it's really awesome that I get to spend so much of my time doing the parts that I love, and that, building this website allowed that, but also allowed small businesses to really come in at an earlier time in their journey before things get scary. Yeah.
That's fantastic. So, for anybody that's tuning in with us today who just doesn't know enough about trademarks yet, can you just give us the brief rundown of what is a trademark and how do you know when you need one?
So a trademark is anything that identifies the source of goods or services. So let me give you some examples. The Nike swoosh, right? So that's a symbol. Okay, so that everybody knows. If you see that on the side of the shoe, you know who made those shoes, unless you bought them on Canal Street and then they're knockoffs. But, right, you know where that came from. The word Nike is also a trademark. The phrase just do it is also a trademark. But then there are other trademarks that are really cool. When you open your Apple computer and it goes, "Wong," that's a registered trademark. When you go whoosh, 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 with your toy lightsaber, that noise is a registered trademark. The
I did not know
smell,
that.
yes, the smell of Play-Doh is a registered trademark,
What?
right?
Wow.
So yeah, and there's actually a touch mark. I love this touch mark. There's a wine company, and the label on the bottle feels like cork. And the feel of the label is a registered trademark.
Wow.
How cool is that?
That is so cool. So
Right?
you can trademark sight, smells, sounds, tastes. Can you do
Tastes
tastes?
are hard. In order to be a trademark, it has to be something that the consumer experiences before they make the purchase. And
Oh,
typically, you don't really experience a taste
no,
until after it's all done. Yeah.
unless it's a
So,
really strong
yeah, so
smell.
that doesn't, I believe me, I have been sitting here for 30 years waiting for a taste mark. And so
So
far,
that's a delineation I did not know before either, that a trademark is something that the consumer has to experience before they make the purchase.
right, exactly. Yeah. Just a
Great.
color, right? So
Yeah.
if you're in New York City, if you're somewhere and you see somebody walking down the street with a little bag and it's that very particular color blue, they've been to
Tiffany.
Tiffany's.
Hmm.
If you see somebody walking in front of you with high heels and the sole of the shoe is red, they're Louboutins.
That's right. Mm, amazing.
Isn't it cool?
Yeah, that's super cool.
Right.
Okay, so speaking of trademarks, trademarks and intellectual property, how are they different?
Right. So trademark is a subset of intellectual property.
Okay.
Intellectual property consists of four things: trademark, patent, copyright, and trade secret. And that's it. That's all there is. If it doesn't fit into one of those categories, it's not property and you can't own it.
Oh,
Okay. So you can't own an idea. You can own an invention, but only if that invention is sufficiently novel and non-obvious and you apply and receive a patent for that. Right. So trademark, we just talked about what that is. A patent, there's actually two kinds of patents if we want to, right? So there's design patents, like an Eames chair has a lot of design, is patented. There's a lot of aspects of the visual of a iPhone that are design patents. There's a huge case going on right now. Lululemon is suing Costco for Lululemon actually has a design patent for some of their tops. And Costco is creating knockoffs of those and selling them. So Lululemon is suing them on the basis of their design patents. So those are patents. Copyright protects things like books, poems, statues, architecture, paintings, stuff like that, plays, choreography for dance, things like that. So creative things like that. And then trade secret is exactly that. It is something that has business value that is kept secret. The example everybody always uses is the formula for Coca-Cola, which I have a feeling a really good flavor chemist could probably copy that. So really what Coca-Cola owns is the shape of their bottle, the script Coca-Cola, the words Coca-Cola, things like that. The one I like to use are the algorithms for Google search engine.
Oh,
that's a trade secret. Yeah. And has tremendous business. Has tremendous business. Yeah. And the only way to protect a trade secret is you have to protect it, right? So you have to make sure that the only people who have access to it, even within your company, are the people who have to use it. So if your trade secret is your amazing list of customers and the receptionist has access to all that information, then it's not a trade secret.
Wow. I just didn't know I was going to learn this much today.
I know.
After this call, I'm just going to be done because I'm going to have all this new information in my head that I didn't have before.
Yeah.
And I thought I knew something about this. I did. Okay, this is great. What kinds of trademarks have strong legal rights? Because I'm hearing a lot of, you're going to open yourself up to lawsuits if you don't do this well.
Right. Or just losing it. Right. So there's 5 in the world of trademark law, there's 5 categories. So there's generic. So the generic word for something can never be a trademark. So you can have Apple brand computers, but you can't have Apple brand apples. Right. Because if you sell apples, you need to be able to use the word apple. Right.
Yeah.
Now, sometimes words start off as trademarks and then they commit genericide because they become the generic word. Zipper, aspirin, words like that used to be a trademark and that now, because they have become the generic word, the company that once owned those rights no longer owns those rights because they have now become the generic word.
Wow. So there's almost a danger in becoming a household name.
It is a huge danger in becoming a household name. Exactly. And companies like Coca-Cola, if you go to a restaurant and you order a Coke and they will say to you, we only have Pepsi products. That's because Coca-Cola sends around spies essentially to go into places and order a Coke. And if they're served a Pepsi, that restaurant gets a nasty gram.
What?
Yes. If a newspaper uses Google as a verb, they will get a nasty gram. Right?
Wow.
Because you're using Google brand search engine to search the internet. You are not Googling something.
Right. But we all say Google it.
Right. And Xerox actually has to work really hard because you're right. That's not a Xerox machine. That's a copier.
Right.
Right. So if you come up with something that nobody has ever done before, you need to come up with a generic name for it at the same time. Right. Yeah. So that people aren't, so that the brand that you're using, the trademark that you're using doesn't just become that. And from a marketing point of view, you would think you want to be a household name, right? You want that to, but then, so your rights go really, 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 really big, really strong, really powerful, really valuable. And then they go 0.
Right.
Yeah, so it's a problem. Yeah, yeah, you don't want to go there. So that's generic. The next category is merely descriptive. Merely descriptive trademarks are really Office Max, Office Depot,
Mm.
really weak, right? Super weak, super bland, like from a legal point of view, almost impossible to, really, really hard to defend. From a marketing point of view, just shoot me. So generic, merely descriptive. The next one is the sweet spot, suggestive. So a suggestive mark tells you a kind of what you're going to be getting, but doesn't come right out and say it. So staples,
Oh, right.
right?
Yeah.
Yeah, so it means, the little thing you put in the stapler, but that's not really what it means.
And
It
it also just means basic things that you need.
right, that's right.
Yeah.
Right.
Yeah.
And one of the problems with merely descriptive marks, which we'll get into, is what happens when that thing doesn't exist anymore. Nobody wants one. Like
Right.
if you're Radio Shack,
Right.
because if you ever have to pivot, you're not right. I mean, who knows what, right? That's why my company is Beeline. And the registration is for legal services. This doesn't say anything about trademarks, right? Because
Yep.
I can create other modules. I can do this with other parts of practice, right? So generic, merely suggestive is perfect. Nest is another one, brilliant suggestive mark. Doesn't say anything about thermostats or cameras or anything. It says you're home and everything's going to be okay now, which is the only thing they want to connote, right? It's
Yeah.
like you give your customer the feeling that they're going to have when they're using your product or service. Right. So that's like the awesome. Suggestive is where really strong marketing rights meets really strong legal rights.
Right.
And then on the farther end, where you're really, really strong legally, but you're starting to lose some power on a marketing point of view, there's arbitrary words like Apple for computers, although technically that was a suggestive mark because you're probably old enough to remember that the reason Apple came into existence was because IBM had completely locked up the commercial market for computers. And they wanted to go after the educational market, right? So it was an Apple for the teacher, right? But nobody remembers that anymore. So now it's just an arbitrary mark. And then fanciful marks, which are just completely made up words, like Lululemon or Pentium, or just words that aren't even words at all. Those, so those are really strong from a legal point of view, fanciful, arbitrary, suggestive, super strong. But as you get down into the arbitrary and fanciful, you're losing some value, some marketing value.
Right.
Yeah.
Yeah, because you have to explain too much who you
Right,
are, what
exactly.
you are,
Yeah.
what you get,
Yeah.
what
Well,
you can do.
you want your trademark to connote something. If your trademark can make somebody feel something, they're going to remember it.
Yeah.
Right. If I asked you where's the closest Office Depot to your home, you're probably going to give me the address of an Office Max.
Probably.
Right. But
Or
I
I'm
bet
not
you
going
know
to
where
even know if
Staples
that's an
is.
Office Max, or do I have an Office Depot in my town? I'm
You
not
might,
even sure.
right?
Might be Office Max.
But I bet you know where the Staples is.
Yeah, we don't have one, and I
You
know
don't
that
have
for
one.
sure.
Okay. Right. Yeah. But it's like that one sticks in your head, right? Yeah.
Yeah,
Yeah.
it does. Yeah, I can see the red
The
letters.
logo, like,
I
yeah,
can see all of it in my mind just immediately.
exactly. Yep.
Yeah,
Magic,
brilliant.
huh?
Brilliant. All right. So, how long does a trademark last? If I were to get one, how do I maintain that?
Right. So if you get a trademark registration, you have to renew it between year 5 and 6, and then between year 9 and 10, and then every 10th anniversary. So
Oh, okay.
it's really every 10 years, except they put in that one extra one. And they can last. So patents expire, copyrights expire, trade secrets, somebody releases it to the public.
Right.
Trademarks can last forever. They're Zildjian, the cymbals, like in a drum set, Zildjian cymbals. That company has been using that trademark since 1623.
Wow.
And there's a company in Japan, hang on, it's a construction company, I think it's Kongu Gum, I'm probably pronouncing it wrong. And they have been using that as a trademark for construction services since AD 578.
What?
Isn't that cool?
Yes.
Yeah.
Super cool.
Super cool, right? In the United States, like the oldest registrations are in the mid 19th century. So like Levi Strauss, I think is like 18 something, right?
Yeah.
Louis Vuitton goes back, I think, to the late 19th century. So there are a lot of trademark registrations in the United States that have been out there for 150 years.
Wow.
Yeah.
Since
And
the
so,
beginning.
yeah. So other stuff can expire, right? I mean, I would always ask people, would you rather have all of Intel's patents or the Nike brand?
I don't know the answer.
There is, right, and that's right, that itself is interesting, right? Because everybody thinks of patents as being like massive, but they expire, right? They disappear, they're gone. And you have to constantly stay ahead of the competition, right? And if you're in an industry that's changing, that patent that you got, even if it doesn't expire, it's worthless because the industry has moved on. But the Nike brand, it's just a trademark, but holy cow, like think about how much that's worth.
Yeah.
Yeah.
Huh.
Pretty cool, huh?
So good. So good.
Okay.
All right. Let me see.
Oh, wait. So you asked, right. So you asked also, so you asked, and I'm going to be super pedantic here. You said, how do I know I need a trademark? Okay. So you have one, right? There, so to get a patent, you have to actually apply to the government and they will grant you a patent.
Okay.
But with copyright and with trademark, they just magically come into existence. Your common law rights. So if you start to use a word or a phrase or a logo or something like that to sell goods or services, you start acquiring common law rights. And when you start dealing with the trademark office, what you're doing is you are registering those rights.
Oh.
Right. So, and by registering them, they become stronger and bigger. And I'll give you a couple of examples. So your common law trademark rights are only going to reach as far as your commercial reach. Okay, geographically, they aren't going to go past that. So let's say you're a real estate agent and you're only licensed in Connecticut, then that's it, right?
Yeah.
That's all you're going to get. Maybe you have some clients who are in New York because they're buying a vacation home. So maybe you might get that. Or, let's say you're only in New England and you have a particular trademark that you're using for that. Somebody can open another one in California using the exact same name if all you're relying on are your common law rights. By registering them, you get the whole country, whether or not you've ever sold anything into California or Texas or Montana, it doesn't matter. You still get the whole country. And there's other powerful things that you get from that, which they don't sound powerful unless you've actually dealt with it. But for example, if I have a trademark registration and I think you're infringing, you have to prove I don't have the rights instead of me having to prove I do.
Nice.
That doesn't seem like a big deal, but it is. And the other reason it's a big deal is that most people have never heard of common law trademark rights. So if I'm writing a cease and desist letter on your behalf and I don't attach a copy of your registration, chances are the people on the other side, even the attorney on the other side, might think you don't have any rights because you didn't register, which is not true. But it's, when I tell people what the difference is, I describe it as when I write a cease and desist letter, it's the difference between poking you in the arm with a toothpick and hitting you upside the head with a baseball bat. I mean, it's so much more powerful. It's just easier to get people to stop if you've registered the mark.
Yes.
So that's the trademark thing. And copyright works the same way. As soon as you create something, as soon as you paint a painting or write a poem or write a book, you have copyright. And you should use the little copyright notice. You can register that copyright and make it stronger, bigger, more powerful, but you still have the rights, even if you don't register.
That I didn't realize either.
See?
I'll be so smart by the end of this day.
Okay.
Thank you for that.
Yeah.
All right. So I know that you and I have talked about this in a previous conversation, but I think it's really important. I want this information put out there for our audience as well. I know that we have the USPTO, the United States Department of Trademarks.
The U.S. Patent and
Patent and
Trademark Office.
Trademarks. Thank you. I'm like, okay, I'm missing a word in there. Patents and trademarks. And you can apply for these on
Right.
your own.
Yes.
But give us a little history because I personally would hire you to do this. And there's really good reason for that.
Yeah.
And I'm not selling you to anyone. I'm just, this is my own personal preference, but I do know enough to know why I
Right.
would definitely go that route. So can you explain a little bit of like how did it even get started? And because the USPTO does have a website, you can go out there, you can take a look. In fact, NAWBO partners with the USPTO. We highly encourage that you protect your ideas and you protect your business.
Yes.
And I really want you to do this. We want you to be successful. And there's several routes you can take to get there. Explain a little bit to us, like how did it start, and why would somebody use an attorney to do
So
this
let me
with
kind of start at like the 10,000-foot level. So 20 years representing startups. And when I sat down to do my own, I would say the biggest lesson that I learned from having represented so many startups, some were successful and some not, is if you're the founder or one of the founders, there's some things you do well, and there are some things you do not do well. And if you want to be successful, you have to go and find somebody to do the things that you don't do well. So when I started Beeline, I did not do this. I hired a former client of mine to come up with the word Beeline and to come up with the logo and my palette and to pick my fonts and all of that stuff, because that's not me. I did all of the documentation for the website, but I didn't try to code it because that's not me. And I have an accountant, right? Because that's not me. And trademark is the same thing. So if you file your application and you get what's called an office action. So after you file the application, they're way behind. So it's taking like 6 or 7 months. So 7 months after you file your application, you're going to get a notice from the trademark office, which is called an office action, that will say, we're refusing to register your trademark because of the following things. And sometimes you can then bring in a lawyer and like me, and I can respond to that and fix the problems. Sometimes they're not fixable and you have to start all over again. The hardest part of my job is not filing the application and shepherding through the process. The hardest part is before you file, you want to know what the trademark office is going to say 6 or 7 months from now. And if you get a refusal because your trademark is generic or merely descriptive, because they will reject on those bases, you want to know that before you go in. And you want to know whether or not it is confusingly similar to somebody else's trademark. Because if that's the reason for the rejection, it's going to be really hard to, it's like crazy expensive to fight that. And normally the answer is, okay, now you need to change your trademark. And then how much is that going to cost you? First, you have to redo all your materials. You've just built up, you launched and you now are starting to get a lot of customers and everybody recognizes it. And now you got to start all over from the beginning and you have to tell everybody, you can spin it. Hey, we decided to rebrand, happy reason. You can spin it, but you've just spent all this time and energy getting people to know you by one name, and now they have to know you by another name. So you want to get it right at the beginning. And a lot of the time, the first thing I have to tell a client is you can't use that trademark. Not only can't you register it, but if you use it, you're going to get a cease and desist letter. So don't do it. And that's really, really, really bad news. But what's worse is to find that out 7 months from now, or a year from now, or 2 years from now, right? That's a disaster, right? So you don't want that. You want to know before you file what's going to happen with that application. And people are used to doing things like domain name searches, right? If you want to buy a domain name and nobody else has that exact combination of letters and numbers, you get that domain name. But it doesn't work that way with trademarks. It's a confusingly similar standard. So, for example, I once had a client, the client wanted to register catology for cat boarding services. Okay, I did my searches the way I usually do, and it was then refused registration because there was already somebody who owned dogology for dog boarding services. Now, I was able to argue with the trademark office examiner by presenting a long list of cat suffix, dog, same suffix, same goods and services, different companies. Like I produced like I spent a day like finding those right. So I was able to argue, but that gives you an idea of the concept of confusingly similar, right? It's not a one-to-one correlation. And it depends on what they're selling, right? We can have Dove for soap and Dove for chocolate, and that's okay. But, so it's more technical and legal analysis than just that one-to-one correlation. And there's rules like the doctrine of foreign equivalence, right? So if your word means something in a foreign language, then you have to translate it into English and then see if it's confusingly similar, or if it's generic, or merely descriptive. And spelling it different doesn't matter, right? Right? You can't register Nikey for Nike and start selling shoes. We all know, like, there's no freaking way that's happening, right? So there's all these rules that are piled on top of this whole confusingly similar situation. And it's not that straightforward. And you want somebody who's actually done this more than once and who has who knows how to do the search with wildcards and all that other stuff so that it'll actually capture all the problems so that you'll know before you file rather than finding out the bad news 7 months from now. So, so for the general reason that you should do the things you do well and find somebody to do the things you don't do well, that's the general reason. But the more specific reason is your chances for success are lower if you do it yourself. And the consequences are down the road in a way that makes those consequences more severe than if you knew it now. So those really are the two reasons.
Yes. And from what you and I were talking about earlier today as well, the fee structure is changing at the USPTO. So you will now be charged more for making mistakes.
Yes. Yeah. So even if you make a mistake, like you have to provide an actual street address to the trademark office. So if you provide them with an address that's like a UPS kind of thing, they are going to charge you $100 for that screw up.
Whoops.
Right. Yeah. And there's like 15 of those, I think, 14.
Yeah.
14 different. Yeah.
So if
things
I'm a
that you,
small business owner and I'm thinking, well, I'm not sure that I can afford an attorney to do this for me, I'll do it myself because I'm
yeah,
smart. I can read instructions and I
yeah,
can download their
yeah,
instructions and I can figure this out. There's a lot of little picky things that you could
yeah,
accidentally do wrong.
yeah.
And
And
when
if
it
you,
gets
yeah,
rejected, it's going to cost you, it's going to
yeah,
cost
yeah.
you
And yeah,
anyway.
and if you have, if you describe your services in a particular way, I might be able to describe them in a different way that will take you from a $550 filing fee to a $350 filing fee.
Yeah,
And if you're in 2 or 3 classes and I do that for you, I've just saved you $600, right?
exactly.
So there's all these things. It looks so straightforward, but it's not, right?
Yeah.
Yeah,
Until you're in
yeah,
it, right?
yeah,
Yeah.
until you're in it. Yeah,
Kind of like whitewater river rafting. It doesn't look that hard, but go
right,
get a boat.
right. Yeah,
Somebody knows how to make this thing
yeah,
work
exactly.
and
Yeah. And
avoid the
there's
rock.
also, I sometimes save people, like I had a client just this morning send me an email, and I did her trademark registration a couple of years ago. And now she's going to be putting she's going to be doing this. She's going to be putting her logo on shirts and stuff.
Mhm.
And I don't have a trademark registration for shirts. Like, I don't care. Like,
Right,
nobody's gonna do this. Like, it's
right.
right. So I just saved her money because I just told her, you don't need to, like, it's not like you're Nike, right? It's not like you're, some company where their logo has this cachet to it. And so there's going to be knockoff t-shirts. Don't spend the money, right? Sometimes my advice is just
Yeah.
don't do it, right? So yeah, that can also help. And another thing, so let me see, where do I have the only way? Okay, so I could have filed one trademark registration that had my logo and the word and my tagline.
Mhm.
One, you can do that with one application. And that seems like a really good idea until you get to that first renewal, right? And then if I have changed the font that I use for
Oh,
mine, or if I'm not using it stacked up anymore, instead I'm using it with
yeah,
the B over here,
yeah.
or I've changed my tagline, I can't renew it. I have to start all over at the beginning, right? So if you're just going to do one thing, you should just register the word mark, no particular font, because fonts change, right? Styles
Do.
change, no font. I mean, unless you're Coca-Cola and you're using that script, no font, right? And do your logo separate because logos change, right? So again,
Wow.
that feels like it's costing you more, but in the long run, it's going to save you time and money because you don't have to start all over at the beginning. And there's a lot of things like that where the obvious thing to do is really not such a good idea.
Well, and that's a really good point because if you have to renew it that first time between year 5 and 6, I mean, that renewal, that's pretty quick. I mean, as far as
Yeah,
owning a business is concerned,
yeah,
I mean, if you make it to year 5 and then it's like, oh, wait, I've got to renew all of this again
yeah,
and then renew it again at year 10.
yeah,
So even if you're building a business with the idea of selling the business, you're probably still going to own this business 5, 6 years from now,
yeah,
and you're
yeah,
still going to have to do that
yeah,
renewal.
yeah.
So
And
yeah,
yeah,
that's
and you
really
don't want
good
to start all
information.
over again, right?
Yeah,
Because
you don't want to start all over again.
yeah, you don't, because now you've lost your priority date.
Right. And you are going to want to update your font, update your images,
Yeah,
update
because
those
that's
things
what people, yeah, I
as
had a
things
client
change.
call like back in March of this year. And I had the same conversation with her when we were filing her application. And she said, no, I know I'm never changing my logo.
Hmm.
So we filed them together and she called and she said, remember that conversation we had where you told me not to do this? And I said, I was never changing my logo. And I said, yeah, I'm changing my logo
Oh no.
because stuff changes. I
I
mean,
do.
it just does, right? But that word, if that word is strong and it allows you to pivot, unlike Radio Shack, then you're going to have that forever, right? So, like,
Right.
do that, protect that. That's the most important thing.
Exactly. So speaking of images, let's talk for a minute before we wrap up about AI technology and AI generated images. And what does this mean in the copyright
Right.
trademark world?
So there are two issues that really come up with AI. And one of them, we're not sure what the answer is yet, but the question you're asking, we know absolutely 100% sure. So, and this goes for images as well as writing. Anything that is produced by generative AI is in the public domain for copyright purposes. So if I use generative AI to make a logo and then I use that as a trademark, that's fine, because but copyright. So if you have images that are important to your company, or you have white papers that are important to your company, or your company is writing, for example, then you should not use generative AI to produce those things because they're in the public domain. And that means anybody can use them. If you are a graphic artist and in your contract with your client, you have promised to not just give them that thing, but also that they would have the copyright to it, you should not use generative AI, because you are breaching your contract, because you can't transfer a copyright that you don't own, you don't have. If you are a copywriter and you're writing something to deliver to a client, you cannot give them the copyright to that writing. So that's one issue. The other, and we know the answer to that. We've known the answer to that before there was AI. It goes back to there was a macaque monkey named Naruto, and he found a camera owned by a photographer, and he took a bunch of selfies that were freaking adorable. And the photographer found him on his camera, and he published a book of Naruto's selfies. And then a group of people got together and sued the photographer on behalf of Naruto, saying that the photographer had violated and infringed on Naruto's copyright. And the court said Naruto is not a human being and there is no copyright. Only human authors can create copyrightable material. So we've known this even before there was AI, because we've had other examples. Photography back in the 19th century was not initially copyrightable because it was thought to be just mechanical, right? They were comparing it to painting and it was just mechanical. And then over time, photographers said, no, no, no. Like, I knew what hour, I'm Ansel Adams, and I knew what time of day to go out into this place and take this photograph. I knew how to frame it. When I was developing the film, right? So over time, they started to realize that creating a photograph really was human creativity. So we've had this issue for a long, 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 long time. And there is no sign of this changing. Now, it would literally take an act of Congress to change that. The other issue is that sometimes what AI spits out is somebody else's copyrighted work.
Right.
Right. So if you just, so far, if you just ask to do it in the style of somebody, that's not copyright infringement, but there are there's lawsuits going on right now that might change that. We don't know that. But the New York Times lawsuit, the lawyers fed prompts in, I think it was OpenAI. The lawyers fed prompts into OpenAI, and then it spit out like this much column length of a New York Times article without attribution. Right.
Oh.
So it's possible that you could say AI, ask AI to write you something, and without even knowing it, it was stolen from somewhere else. And knowledge of copyright infringement is not required. You don't have to know that you are infringing to be infringing.
Yes.
right? So you had no idea that came straight from the New York Times. You didn't know that, and so you just published it. It doesn't matter. You still committed copyright infringement. So there are definitely some dangers. If there's if you want to use it to write an email to somebody, or if you want to use it to write your blog post because your blog posts aren't really all that owning them, like who cares, then go ahead and do that. But you have to realize that you do not own that.
Yeah.
Yeah.
God, good information. Yeah. And that's interesting because I was just thinking about this yesterday in anticipation of talking to you today, because we're looking for a new pool cleaning company. And there was somebody on social media who was also looking for a new pool cleaning company. So of course I went on there and took all of those recommendations and looked at all of them, because now I don't have to ask the question. Somebody else asked it for me. That's great. But I started clicking through, and there was a small business here, and all of their images, their logo and everything that they're using is very clearly AI generated. And I thought, I just wonder,
Yeah.
could they even trademark that? I don't know.
Well, you can trademark it because, again, what you're not protecting right? So if you think about it, like think about copyright as auto insurance and trademark is homeowners insurance.
Okay.
Right. And if you have auto insurance and your house burns down, not going to help. Right. So trademark allows you to prevent somebody from using that word or symbol to sell stuff. Whereas copyright protects you from having somebody copy that.
Okay.
Right.
Now that makes sense to me. Yes.
Right. So that's right. So if you use AI to generate your logo, you can still register it as a trademark, assuming it's not similar to somebody else's logo, which again, if you're using AI, who the hell knows where they found that logo?
Very well,
right? It may be somebody else's.
Kind of familiar to me,
yeah.
but
So
I can't tell you from where.
Just the fact, but the fact that AI created it doesn't matter. But if you're creating something that you want to protect by copyright, you don't want people to copy it, like a blog post or a book or a white paper or a painting or something like that. Then what you're worried about there is the copyright. And so, you want to make sure you have the right kind of insurance for that thing. Right. And if you use generative AI, it's uninsurable.
Gotcha. Oh.
Isn't this the most fun thing ever?
See, I knew you were going to be fabulous, and then you just exceeded even my expectations. And I set a high bar. This has been so incredibly full and informative and useful. And at the end of this, when we edit this, we will have all of your contact information very, very viewable for everyone as well. Because I want people to be able to get a hold of you. I want them to go to your website. Your website is so useful.
Well, thank you. Thank you. And honestly, I love talking to people. If you didn't notice, I love talking to people about this. So if people just have questions, I have learned in the course of many years that if you are asking me so many questions that I feel like I need to be paid for this, I will say that. Right. But people should feel free to reach out to me and ask a question, or if there's something they need more information about. The other thing is I often use my blog as a way to explain stuff. And so a lot of times I can say, hey, read this blog post, read that blog post, because that'll make it really clear for you. So there's a lot of content out there that people can access to.
So great. Thank you so much. Yeah. Thank you for making this so accessible to the business owners out there. And, and for being so approachable, for being the most fun lawyer I know.
Thank you.
And all my lawyer friends out there who watch this, please don't get your feelings hurt. Yeah. But you need to have a cuter logo. I'm just saying.
They do.
Because Michelle's doing it and it's working. It's working. Okay. Thank you, Michelle.
Thank you.